In the late 1970s, the trade union movement in the United Kingdom was massively powerful, but they used that power recklessly with an extraordinary lack of understanding of basic economics, demanding wage rises when the government was trying to curb inflation. Much of the 1970s genuinely became a contest between the government and the unions as to who would govern. Union strikes shut down much of the UK and inflicted hardship on millions. The unions were equally aggressive towards Labor and Conservative governments. When Margaret Thatcher was elected in 1979, one of her key objectives was to significantly reduce union influence on politics. The unions responded with a range of strategies, including some which were specifically intended to reduce British defence capability. It really was reckless and stupid. The government communications headquarters was basically a spying organisation monitoring the communications of overseas governments and protecting the security of British official communications. It was mostly staffed by civilian civil servants and not by military personnel. Most of those civil servants were union members, and the union had begun industrial action specifically intended to compromise British security by interfering with the operations of the communications headquarters. Thatcher was not only Prime Minister but also the Civil Service Minister. She issued a civil service order prohibiting staff at the government communications headquarters from being in a union. She undertook no consultations and did not grant natural justice to the unions or the members. They sought judicial review. The minister argued that natural justice had not been provided because if it had, the unions would simply have responded with strikes which would have threatened national security, and that in those circumstances natural justice was not required. The court agreed. Lord Scarman said that if the court is satisfied that the interest of national security is a relevant factor to be considered in the determination of the case, the court will accept the opinion of the Crown or its responsible officer as to what is required to meet it, unless it is possible to show that the opinion was one which no reasonable minister advising the Crown could in the circumstances reasonably have held. From this case, we learn that national security forms an exception to the usual requirement for natural justice. Natural justice need not be provided if it will endanger national security, and the government is the judge of whether that's the case.